When can I settle my Indiana injury case? An Indiana injury case can be settled once all medical treatment has been finished and a doctor has released the person from future medical treatment. Typically, doctors call this maximum medical improvement. And so once a person injured in an accident, whether it's a car crash, whether it's a slip and fall, whether it's a dog bite, settlement of that case can begin once treatment is finished. Parts of an injury settlement include medical bills, medical records, lost wages. Some people even keep track of the mileage between their home and doctor's appointments, diminished earning capacity. There's so many parts of personal injury settlement in Indiana, but for the most part, settlement negotiations can begin once a person has done with treatment. The reason why settlement negotiations can begin once a person's done with treatment is because a large part of an injury settlement is a person's pain and suffering. And so if the person's not done with treatment, there's no way to gauge their pain and suffering, because if you go 10 days before you're done, well, there's 10 days of treatment, and we can assume a person is not feeling as great as they would have felt if they had not been in an accident. If there's 300 days of treatment, we can also assume that a person was not feeling as good as they would have felt if they'd not been in an injury accident for 300 days. And so there's a greater amount of money that can be claimed for someone who's been treating longer. It's not as simple as saying, well, you took longer to get treatment, and therefore you have a higher settlement, but the length of treatment, type of treatment, what was treated, what was injured, those are all factors. And it's impossible to properly gauge a settlement for an injury case in Indiana unless a person's finished with treatment. There are some giant exceptions to this finished treatment before negotiations. In some cases, a person who's at fault, their insurance policy is very low, and it's very obvious that even though a person's in treatment, that their at fault party's insurance will never be enough to cover the actual damages. Well, maybe in those cases, don't have to wait until the person's finished, because we know that a person's insurance is not going to be enough to cover our client's damages. There are some cases where a person will never be done with treatment, and that's a very sad reality for people who are experiencing serious injuries, which is very sad. But in those cases where we know treatment's not going to ever be done, it's going to be continuous, well, we don't have to wait until a person's done with treatment, because that may never come. Now, if you're trying to handle a case on your own, an insurance company for the at-fault party might try to tell you, oh, we don't have to wait until you're done with treatment to give you a settlement. How about we give you $2,000 or $3,000 now, $5,000 now, $10,000 now, and we'll continue to pay for your medical bills. I'm going to let you know that's a dirty trick by the insurance company. So insurance companies would love to just hand you some money and say, okay, that's it. But once they hand you that money, there's no going back and expanding that pot. So say you need more treatment than you thought. Well, guess what? Maybe they'll pay for those medical bills. But Mark, they said they will pay for the medical bills. They'll pay for related medical bills. And as soon as they know they've paid you a settlement, they're going to be questioning those medical bills, trying to dog you down until you either stop bugging them or you agree with them, oh, it's not related. So for example, you're in a car crash and your back and your neck hurt. You go to your doctor and they say, okay, we'll continue paying for medical treatment. Here's a couple of $1,000s. And then all of a sudden, 3 months later, you keep going to the doctor. They're going to be like, hey, come on. How much? Enough's enough. Your back still hurt from an accident? You didn't break a bone? They're going to be arguing with you. And then they're going to say, well, hey, you know what? You had back problems before this car crash. We shouldn't have to keep paying for your back problems forever. They're going to push back. And if you've accepted a settlement before you're done with medical treatment, you'll have no ability to force them to keep paying for those medical visits. They're going to fight you and they're going to argue it's not related. And the issue of is it related is an issue of fact. It's triable technically to a judge or a jury, but most attorneys will not get involved if a person has taken a partial settlement on their case. So don't do that to yourself. So the only true and correct answer for when can I settle my injury case is when a person is done with medical treatment, or in very rare circumstances, treatment will never end. Therefore, we have to work on a settlement now. Or, last or I promise, a person who's caused the accident, their insurance is not sufficient to ever cover the treatment, even if the person does finish. So we can start in those cases earlier as well. And that's both of those examples are very, very sad. And we hope those don't happen to any of our clients. So don't even think about settling your injury case until you're finished with treatment. Here at the Mark Lopez Law Firm, we know that people who have been in accidents and injuries experience a great deal of frustration trying to take care of their case. Allow us to turn that frustration into compensation. Give us a call, 317-632-3642.